Well, good evening, ladies and gentlemen. For those for whom I've not had the opportunity to say hello to personally, I'm David Bell, the Vice-Chancellor at the University of Reading. It gives me a great pleasure to welcome you to the inaugural event in our Alumni Lecture Series. And our aim in this series is to recognise the many and varied talents of our alumni, to showcase the impact that they have upon the world, to act as an exemplar for our current generation of students, and of course to celebrate our great university. This evening we are honoured to be the guests of Smith and Williamson, a company with an international reputation, founded in 1882 in Glasgow. A fine city, if I might be allowed to so comment. I'd like to, at this point, to take the opportunity to introduce Willie Hartley-Russell, who is a partner here at Smith and Williamson, who are generously hosting our event tonight. But just before passing the floor to Willie, I'd like to pay public tribute to him for the continuing support that he has given to the University of Reading. So please welcome your host.
Ladies and gentlemen, sorry, I'm not going to use that. It's a particular pleasure to welcome you to Smith and Williamson in the City of London for this keynote lecture by Dr. Saul Lehrfreund. I hope I've pronounced your name correctly. Smith and Williamson is a unique institution in the city in that we are not only an investment management firm managing around about £16 billion of assets, but we're also a top 10 accountancy firm. And as David quite rightly said, founded in Glasgow in the late 19th century. The firm is independent and managed and owned by other partners. So we are delighted to be partnering with the university for this alumni lecture. As a member of the court of the university, I have been greatly impressed by the giant strides that the university has made over recent years. The merger of the triple accredited Henley Business School, the foundation of the University of Reading Malaysia, which opened I think on the 25th of February, and the proposed creation of the Thames Valley Science Park at Chinfield are just three examples. The university is very fortunate to be led by Sir David, who has been inspirational in his leadership and in what the university has achieved since he was appointed in December 2011. So we're delighted to sponsor this evening's alumni lecture, and I very much look forward to listening to Saul on the subject of the death penalty. There is one housekeeping matter which I should bring to your attention. We are not expecting a fire alarm this evening, but if there is one, there is some stairs by the lifts, and I will guide you through where you should go. Finally, I would warmly invite you after the lecture to join us next door for drinks and some canapes. So I'll now hand back to David to introduce Saul.
Thank you very much, Willie, and thank you for those very kind and generous remarks. Ladies and gentlemen, you may have noticed, of course, the photographer and the camera in the room tonight. Not surprisingly, the camera will largely focus on Saul, but we wanted to film tonight's event so we could make it more widely available to those that can't join us this evening. The University of Reading has long been a champion of tolerance, inclusion, and the recognition of human rights. We were the first university in the country to appoint a female professor, Edith Morley, in 1908. We provided books from our library to restock the devastated University of Hiroshima. Lord Wolfenden, then John Wolfenden, a previous Vice-Chancellor, was the author of a landmark report in the 1950s that certainly started to change the climate in relation to the decriminalisation of homosexuality. And I'm proud, therefore, to introduce one of the finest exponents of this tradition, our main speaker for this evening, Saul Lehrfreund. Saul has run the Death Penalty Project since its inception in 1992. In 1995, the project won the category of Best Pro Bono Activity at the inaugural UK Lawyer Awards. And in the same year, Saul received an individual award from the International Bar Association for his contribution to the promotion and protection of human rights. In July 2009, we were proud to recognise Saul with an honorary degree of Doctor of Law in recognition of his many achievements. Saul has got a whole number of other interests and responsibilities, but I think much more importantly, we now want to give him the opportunity to tell us this powerful and inspiring story. So, ladies and gentlemen, please welcome our inaugural alumni lecturer, Saul Lehrfreund.
Good evening, everybody. It's an honour, it's a privilege to be here this evening. Lots of friends, people that I studied with at Reading many years ago, some of my old teachers at Reading. I even got a school friend here, so it's really it's a real privilege and honour to be here this evening. And what I'm going to do is I'm just going to talk around this subject. I mean, there are three key words: controversies, trends and challenges, and I'll just try to explain and map out what's really happened in the last 25 years since I've been involved in representing prisoners facing the death penalty around the world. So here goes. Now, the organisation, the Death Penalty Project, this works. Okay, so we're an international human rights organisation. We've been operating for 25 years. And the beginnings of the organisation, we started as a tiny little operation, little outfit in a great solicitors firm called Simons, Muirhead and Burton, which still exists today. And without that firm, without the support of the firm, none of this would have happened. And the reason why it happened was because it's a very odd thing. Some people will know, but a number of countries, former British colonies, have maintained the Judicial Committee of the Privy Council in London as their final court of appeal. And this oddity means that certain countries who retain capital punishment still bring their appeals up to London before their lordships, which is basically judges from the Supreme Court determine capital appeals today, in this very day, from a number of former British colonies who are now independent nation states. And Simons, Muirhead and Burton, and in particular my former partner and former boss, Bernard Simons, he felt that he had a duty to assist people to bring their cases to this court. Most of the people we represent, 99%, can't afford to pay lawyers, so the services were offered pro bono. And that's always been an ethos and something that the firm's been very proud to do, and I'm pleased to say that they still support us in doing this. Now, this all started back in 1992, and the real case that launched the project, which I'll talk about later, is a case called Pratt & Morgan. And this case resulted in about 400 prisoners being removed from death row on the basis that the Privy Council rejected the notion of the death row phenomenon, the idea that prisoners could be held languishing on death row for 15 or 20 years. And this case was the first real human rights case coming out of that tribunal that really launched us as a human rights organisation in our own right. It's strange, but we're a tiny organisation. I mean, most of our staff are here tonight, sitting at the back. We're really small. We have a really small core staff. But in another sense, we're very big because we rely on the traditions of the English bar, forensic psychiatrists, psychologists, criminologists, a whole range of experts that feed into our project and provide pro bono assistance. So at any one time, there's maybe more than 100 people working on the cases. It just happens that 92 of them don't get paid. But that's really how we operate. The work is very high impact. We're involved in strategic litigation. We represent individuals, their individual cases, but we try to bring challenges to systems, and this has huge impact. So, as I said, the Pratt & Morgan case, we're able to clean out death row populations pretty much with one case. The other point about the organisation is we're not campaigners. We're not there to preach to other people about whether the death penalty is a good or bad thing. We work with the law as lawyers, and that has enabled us to access so many different countries, ranging from the Democratic Republic of Congo to Singapore to countries in the Caribbean, where we're accepted and respected as lawyers. So we go to court and we fight cases before the judiciary. Hopefully we win, not always, more often than not we do, but we don't also argue for abolition, and that is because we can't. We restrict the death penalty and we try to promote and protect the human rights of individuals who face the death penalty. What we can't do is to get a court to rule the death penalty itself is unlawful. That tends to be in 90% of countries a matter for parliamentarians. So there are distinctions, but we do work very closely with campaigning organisations like Amnesty and many others. So very briefly, we provide a whole range of different services, different activities. 60 to 70% of what we do is pure litigation. But litigation on its own can be a little bit blunt. So we take quite a holistic approach to the whole area of the death penalty, and we supplement the litigation with capacity building, with research, with training, and we provide a lot of expert support to local lawyers that need our assistance. So that's really how we operate as an organisation. But what I thought I'd do at the beginning is just give you a short account of what it was like for me back in 1992, a long time ago, when my then boss, Bernard Simons, I'd only been working for him for 3 months, and I turned up to work on a Monday morning, and he called me in his office and he said, I want you to go to Jamaica. That's where our clients were. And I said, well, okay, sure. And I said, well, when? And he goes, tomorrow. And I said, okay. And I said, well, for how long? And he said, I don't know. And he gave me a one-way ticket. He said, try and clean up the mess. So there was me, not long out of Reading. I then done a post-grad. I had no idea what I was getting myself into. So this is just a short account of what it was like. So way back in '92, as a 24-year-old lawyer with virtually no experience, I found myself standing outside the gates of St Catherine's District Prison in Spanish Town, Jamaica, waiting to see scores of death row prisoners. I was hit immediately by the uncomfortable smell of over 2,000 prisoners being detained in a relatively small area. There was no sanitation, clearly, as 4 men struggled past me with a wheelbarrow overflowing with human feces. The stench, the incredible heat, and the unfamiliarity was overpowering, as was the intimidating welcome from baton-wielding, smartly uniformed prison officers. I was confronted with mistrust and commenced on a journey of talking to, listening, and trying to assist persons waiting to die. One by one, I saw 10 individuals each day, every day for 5 weeks. I couldn't help to be moved by how genuinely pleased they were to see me, to converse, and generally just to talk to another human being. And immediately mistrust and skepticism quickly turned to hope and a feeling that things needed to change. It was uncomfortable, very uncomfortable, but this was the challenge. After day 3, I was greeted at the same gates by the same threatening prisoners' officers in their immaculate uniforms, but by now, as I entered the prison, hundreds of prisoners were calling my name, Mr. Saul, Mr. Saul. This is something I've never ever got used to. Some of the men were terribly handicapped, physically and mentally, and many were clearly in dire need of psychiatric help. Others were visibly traumatized by having spent 23.5 hours each day in a tiny cell, no ventilation, a bucket for a toilet, ill treatment, violence, and worst of all, no hope. And I've learnt that to be without hope or hopefulness is an awful state. And I've learnt that with hope, things can and often do change. Legal visits to death row in those days were totally rare. This wasn't surprising when I understood quite quickly the typical profile of a case. You'd meet your lawyer on the first day of your trial or a few days before your trial, and this wasn't surprising when one understood legal aid fees. No witnesses were called for the defence. No experts were called, medical or otherwise. the jury would retire on average for 15 minutes, and a huge proportion of the cases depended on shaky eyewitness testimony or deeply contested police confessions. Now, this scenario is not atypical to Jamaica, happens throughout the Caribbean, it's a feature of the death penalty in the United States. Now, during my second week in this prison, I met Earl Pratt and Ivan Morgan, and they'd been on death row almost 15 years and faced executions on 3 separate occasions, being dragged to the gallows, only to receive last-minute reprieves. And their case created legal history in 1993, and literally things have never been the same since. And I'll come back to the case a little bit later. But before I do that, I thought it would be useful and instructive to look at how the world has changed so much in such a short space of time. Since that visit to Jamaica 25 years ago, as I'll explain in a minute, the pace of change as regards to the death penalty worldwide has been nothing short of remarkable. But before I talk about the world, let's talk about here. What about the UK and abolition of the death penalty in the United Kingdom? Well, we abolished the death penalty. Last year was the 50th anniversary of the abolition of the death penalty for murder in the United Kingdom. It wasn't until 1998, though, that we actually cleaned it up and abolished the death penalty for treason and other weird offences like piracy in Her Majesty's Dockyard. And we produced a report recently on abolition of the death penalty in the UK. I often go to parts of the world and they always ask me the same question, well, what's your experience? What's your story of abolition in your country, particularly in Japan, oddly? So I thought, well, we should write a report, and this fantastic report was written by a barrister that's done 20 years of pro bono work for us, somebody called Julian Knowles. And what we wanted to focus on was not just the story of abolition in the United Kingdom, but what lessons could be learned from our experience and what could we impart to other people. And the area of public opinion is something that comes up quite often. I'm going to talk about that quite a lot. But one of the lessons from abolition in the United Kingdom is that post-abolition, popular attitudes tend to shift and conform more closely with political leads. So in 1986 in the UK, based on polls, there was 74% of people in favour of capital punishment. By 2007, this was down to 50%, and in 2014, this was down to 45%. The other thing about public opinion is that age matters, and the lowest support for capital punishment is in the group of 18 to 29-year-olds, and that's simply because they have no expectations of the death penalty. But the other point about public opinion, the salient consideration isn't the abstract question of do you like the death penalty, but it's how strongly do people feel about those particular opinions. And I'll come back to that with some other examples from work we've done in Japan. But in '99, in the UK, 57% of respondents to a survey agreed with the statement that death was the most appropriate penalty for certain crimes, but only 28% strongly agreed. So public opinion is a very interesting area, and I'll come back to it because that's one of the challenges later on. But the second lesson really from the United Kingdom's experience is the matter of wrongful convictions. And wrongful convictions in the UK back in the 1950s, pre-abolition, really shaped the movement amongst elites to move to abolish capital punishment. And I won't go into the details because people will know of the cases, the case of Ruth Ellis, the last woman to be executed, the tragic case of Derek Bentley, and the equally tragic case of Timothy Evans. But after abolition, there were a number of attempts in Parliament to reintroduce a death penalty, 13 I think. And these stopped eventually because of miscarriages of justice, particularly in the 1980s. There are many cases, the Guildford Four, the Birmingham Six, the awful case of Stephen Kisco, who was proved to be innocent by DNA. He'd confessed to committing an awful sexual crime, but the evidence was that he was innocent and he was severely mentally impaired. Now these cases really put an end to any chance of reintroduction of the death penalty. And very interestingly, in '97, we established the Criminal Cases Review Commission. And if one's interested in miscarriages of justice, after the criminal justice process has been completed, that body has heard 500 cases, referred them back to the Court of Appeal, and 70% of those cases have resulted in convictions being overturned. So imagine if we had the death penalty. So that's just a brief story about the UK, which is quite relevant. Now, this is a picture of the world as it is today. This is the death penalty map. Now, today, and this is the good news story, is we've got 108 countries who have abolished the death penalty, and 101 or 102 of those for all crimes in peace or wartime, and only 6 for ordinary crimes. But the pace of change in the last 20 to 30 years has been nothing short of remarkable. So of the 198, I hope I've got this right, independent countries in the world, more than 50% have now abolished. And every couple of years at the United Nations, there's a vote on a resolution calling for worldwide moratorium on the death penalty. Now, in December 2014, the last vote, there were 117 countries who voted in favour of this resolution, and only 38 countries opposed the resolution at the UN, as compared to 55 in 2007. The other interesting statistic, there are loads, is in 2013, only 22 of the 198 countries actually executed anybody. So this is massive change. So things have really moved, and I'll put it this way, from a position of pessimism not many years ago when I started to one of extreme optimism. So if you go back to 1966, not that long ago, 2 years before I was born, only 12 countries had abolished the death penalty worldwide. By 1988, we'd moved up to 35 countries who'd abolished the death penalty, with another 17 having abolished for ordinary crimes and a further 27 de facto abolitionist states. Now, de facto means that they haven't executed anybody for 10 years, and then they slip into that category. And most of those countries were positioned in Europe, in South and Central America, and that was pretty much it. But it was still, by 1988, the pace of change was still very slow. But the movement between 1988 and the present day has just been huge. And the tone's changed dramatically towards increased optimism. As I said, we've got 108 abolitionist countries, and that's a huge increase from the 12 countries back in 1966, and double the number who'd abolished in 1988. And the simple question why, I mean, it's a long talk to talk about why, that's a long thesis. But in short, the debate has moved beyond the view that each nation has the right to retain the death penalty, a sovereign right to retain the death penalty as a repressive tool in its domestic criminal justice system on grounds of its purported deterrent utility or the cultural preferences and expectations of citizens. And instead now the debate is one that the death penalty inevitably and however administered violates universally accepted human rights principles. And that is the nature, how the debate has changed. There's loads of factors, which, as I said, is a huge area. Now, this slide shows, this is the horrible league table. You don't want to be in this league table, and you definitely don't want to be at the top, okay? Now, this is the position in 2015. There have been notable setbacks, according to this table. According to FACT, Indonesia, Pakistan, Saudi Arabia, Iran have bucked the trend, but overall global trends are falling. Just to pick a couple, the United States of America, the number of 28. 28 executions in 2015, the lowest for 20 years, and the lowest number of people sentenced to death for 20 years. The state of Nebraska abolished the death penalty. That's 19 states in the US who have abolished, plus the District of Columbia. That's 20. And over half of those states that retain the death penalty have not executed for more than 6 years. China as well. I mean, China, you look at that and you think, China, that's awful. Well, it is awful, but compared to 1983, when we estimated 24,000 executions, this is a positive change. Why has it changed? There's more professionalism, accountability in the judiciary in China. There's a revulsion domestically at wrongful convictions that have been publicised quite heavily on the internet, and modernisers believe that reputation matters. And all of these factors combined has led to a change in China. I first went there in '99, and the debate was, why should we abolish? I've gone there recently, and the debate is, how should we abolish and when should we abolish? So China is changing. It's hard to believe, but it is true. The other interesting statistic from today is that there are only 9 countries that have executed more than 10 people each year over a 10-year period, only 9 countries. So the world is changing as far as capital punishment is concerned. Now, these are common themes in death penalty cases that we confront all the time. Okay? So in countries of varying cultures, religious creeds, different social and political structures, a combination of these factors arises all the time in so many cases. And not surprisingly, wrongful convictions and unfair trials are a reality in far too many situations. And I'm going to talk about 2 particular cases. But I mentioned the experience of the United Kingdom, but the evidence from around the world is that criminal justice does its best, but it's human and it is fallible. So you have to reconcile having a criminal justice system that will inevitably make mistakes with having a system of capital punishment. And those 2 factors don't reconcile very closely together. And we've done a report, and a lot of reports which are available on our website about, it's entitled The Inevitability of Error, and it talks about wrongful convictions. Now, this is a photograph of a man called Iwao Hakamada. And Mr. Hakamada was convicted of a multiple murder and sentenced to death in the year I was born in 1968. And he's now the 5th man to be released from Japan's death row. After his arrest in 1966, he was subjected to long and brutal interrogations, and ultimately this led to a false confession. He protested his innocence throughout, but after 20 days of interrogation, 16 hours a day, every day, he confessed. At the trial, he retracted the confession, but he was nonetheless convicted and he was sentenced to death. And very interestingly, in Japan, the youngest judge, called Norimichi, the youngest judge on the panel, has always been convinced of his innocence. And he was so traumatized by this particular case that 6 months after Hakamada's conviction, he resigned from the judiciary. And even more amazingly, in 2007, he went on national television to talk about his concerns about this particular case. And this is really quite incredible. But what is shocking in Japan is this system of interrogation where people can be detained in a police station for 20 days still exists today. Okay? So this is quite surprising in a country like Japan, that you don't have sufficient protection for detainees at the police level. And this led to Hakamada's conviction. Now, this is a shocking one. 46 years on death row until DNA proved his innocence. So clothing allegedly worn by Mr. Hakamada did not match his DNA, did not match the DNA of the victims of the particular crime. And key evidence to do with clothing was also withheld by the police. He was eventually released in Japan. He's the 5th man to be released from death row. And we did a lot of work around his case, feeling that this may be a motivator, may be the platform to create a movement towards abolition in Japan. Japan is a very difficult country to move on the question of the death penalty. The government maintain that as long as there is strong public support for capital punishment, they cannot abolish, because it will undermine the state. Okay? It will undermine the democratic institutions of Japan, because 80% of the public support the death penalty. Now, they believe this, and they do their own public opinion survey every 5 years on the death penalty. And this is all down to a member of the Faculty of Law in Reading, Dr. Mai Sato, has done some incredible research on public attitudes to the death penalty in Japan. And Mai, and we've worked with Mai, we've published a number of her reports on this. She's done her own surveys, parallel surveys to the government surveys, and her findings undermine the findings of the government. So Mai's been able to show that public opinion in Japan is not so hostile to abolition as the government make out, and it certainly wouldn't undermine the legitimacy of the state. To the contrary, Mai's main conclusion in her report that she published late last year is that the Japanese public would actually embrace abolition if the government changed its stance. And 71%, according to her research, of retentionists said they'd accept abolition. So Japan is a very interesting area when it comes to the death penalty. Now, I'm just going to move to the second industrialized nation that has the death penalty, which is the US. Only 2 industrialized nations have the death penalty, Japan and the US. Now, very recently, there was a major study done by a number of academics in the United States, And this study was able to show that at least, and it's a scientific study, that at least 5% of death row convictions are unsafe in the United States of America. That's 1 in 20 cases. Could be more. That's a conservative estimate. Now, this is the case of Anthony Ray Hinton, and this is a really shocking case. So just to summarise what's written on the slide, he was charged more than 30 years ago with 2 capital murders. The only evidence against him, was a gun taken from his mother's house, which was allegedly the weapon used for both killings. He was identified in a lineup, although his alibi, which was cast iron, was that he was working 15 miles from the scene of the crime. That was never disproved. The prosecutor had an awful history of racial bias, and he actually said that he thought that Hinton looked guilty and evil based on his appearance. Quite incredible. His lawyer, there's another problem of capital cases, instructed a visually impaired civil engineer with no expertise in firearms as the ballistics expert in the case. And not surprisingly, Anthony was convicted of capital murder and sentenced to death. New evidence, he was represented eventually by a fantastic lawyer, one of the greatest lawyers alive, a man called Brian Stevenson down in Alabama. And Brian, it took 12 years of litigation, and he was eventually able to show that Anthony was innocent and his conviction was quashed. And he was released in April 2015. Time spent on death row, 30 years. And interestingly, he was at that time the 152nd person exonerated in the US. And that's the terrible truth, that this case is not in isolation in the United States of America. And the US is fascinating when it comes to wrongful convictions for the wrong reasons. We're now up to 156 people have been released from death row with evidence of their innocence, and that's since 1973. In the first period on that slide, the average of 3 exonerations a year. We're now up to 5 exonerations a year. And this was something that Brian would have said, that for every 10 people executed in the US, 1 innocent person's been exonerated and released from death row after spending on average 10 years in isolation. So that's the death penalty in the United States of America. So these are the barriers to abolition that we face. I mean, people always say wherever we go that the death penalty is unique to us. It's our death penalty. We say, well, what are the reasons why you couldn't move to having no death penalty? And wherever you go in the world, these are the 3 reasons that come out. Deterrence, arguments about deterrence, national sovereignty, and public opinion. So there are no unique arguments anywhere about why a country should retain capital punishment. So first of all, national sovereignty. Some countries, Indonesia is a fascinating example from recent times with the 14 executions of the foreign nationals. They claimed that attempts by other nations, Australia in particular, in those cases, to bring about abolition or universal abolition of the death penalty should be stigmatized as imperialism and trying to turn a domestic criminal justice issue into a human rights issue. And as far as we're concerned, that's a very poor argument, because there are so many international treaties that regulate how states behave in relation to their captive citizens. So to say that the death penalty is excluded from that makes no sense whatsoever. So that is a very, very poor argument, but it is cited by certain countries. The other area that's often cited is deterrence, that the death penalty has a greater deterrent effect. And there are 3 simple ways to deal with this particular argument. The death penalty hasn't been shown convincingly anywhere through science or any other basis. It hasn't been shown to provide any greater protection to citizens than the alternative punishment of lengthy imprisonment. And there are 3, you can break that down into a lot of them. I mean, there isn't the time to go through, there's so many studies on this. But there are 3 sort of broad areas to look at. One is when executions cease, it's not inevitable that the number of homicides increase. That's the first one. There is no evidence from around the world that once a country abolishes the death penalty, homicide rates go up. That doesn't happen. The second area is that if you compare 2 states with similar demographics, similar socioeconomic profiles, there's no greater reduction in homicides in the countries that use the death penalty. And the third area all comes from the United States of America, where criminologists and scientists for many years have attempted through sophistical social science research, to analyse whether there is any greater deterrent effect or marginal deterrent effect in having the death penalty. And none of those studies can conclusively answer whether the death penalty increases, decreases, or has any impact on homicide rates. So deterrence, I mean, it is fading now as an argument, deterrence. Not many people really cite deterrence with any seriousness, because it is an area, it is a weak area. But the hardest area is public opinion. And those countries that maintain the death penalty generally will cite that the public want the death penalty, and therefore we're elected by the public, and therefore we're carrying out their wishes. And in the background, this was a study that we did on public opinion in Malaysia. And this was to do with the mandatory death penalty. Because one of the greatest vices of the death penalty in the world is the mandatory death penalty. The concept that a judge has no option if you're convicted of a crime but to sentence you to death. So you only have one punishment, which is the death penalty. And in Malaysia, you have a mandatory death penalty for a range of offences: drug trafficking offences, murder, firearms offences that are non-fatal. These are all mandatory crimes. Treason as well. Now, the government in Malaysia said that we have a mandatory death penalty because the people support the mandatory death penalty. So we thought, well, hang on a minute, we don't really know if that's right. So we worked with a great criminologist who's, I think, the world's leading expert on the death penalty, which is Professor Roger Hood. And Roger, who's an emeritus professor from All Souls at Oxford, and was the former director of the Centre for Criminology there. Roger's done a number of studies for us, and he did one on the mandatory death penalty in Malaysia. We got a lot of funding. It's very expensive to do this work. We worked with Ipsos, who are an award-winning market research company, and we did a nationwide survey using a sample of almost 2,000 people. And we asked them a whole range of questions. And we asked them to judge a number of scenario cases themselves to see whether they felt that in every case the only punishment that could be meted out could be the death penalty. So this was a study we did. Now, public opinion generally, I mean, one can't entirely ignore public opinion, and I think my Sarta, if she was here, would agree with me about that quite strongly. But a country, we would say, that is concerned for human rights shouldn't merely accept public opinion as one of the main reasons for keeping the death penalty. And why we say that is because most of the time public opinion is uninformed and is based on misconceptions about the assumed deterrent effect of the death penalty, the fairness rather than the arbitrariness of its application, and the absence of error rather than evidence of mistakes. And this is the problem with public opinion. People don't have the information to really make the decision. And the other point to make, not a very democratic point, but the reality is that abolition around the world has not happened because, or as a result of the demand of the masses. It has happened through political leadership, principled government, moves by the judiciary and elites, including the media. That is what has moved abolition in all 108 countries that have abolished. We can't find one of those countries where it was the public that said, we want to abolish the death penalty. It doesn't happen that way round. And the other point about public opinion, it's really shaped by the use of the death penalty, okay? Because it's to do with expectations. And once the death penalty is abolished, you see that public support starts to wither as expectations change. And the majority in retentionist countries support the death penalty in abstract because they're conditioned and socialised to accept the death penalty as a legal and cultural norms. It's as simple as that. And it's also generational. A generation that grows up without capital punishment has none of those expectations and are far more likely to regard capital punishment as a barbaric relic of another era. And that's really a basic view about public opinion. And what's so interesting is if you go to Norway, and if you look at the response of the Norwegian people to the awful mass killing of all those young people by Anders Breivik, and that was in July 2011. And this is really vivid testimony, because capital punishment for murder was abolished in Norway back in 1905, and only 16% of Norwegians would have favoured the death penalty even in that particular case. So what do we know from the public opinion survey in Malaysia? Well, these were some of the general questions that we asked people, and the findings are really interesting. So these public opinion surveys are very useful tools to get behind the abstract question about simply, do you support the death penalty? So well-constructed social science research by Maisato, Roger Hood and others has been able to show that public opinion is very nuanced and incredibly malleable and quite flaky as well. Now, for example, surveys done in China, Taiwan, this one in Malaysia, we asked people about, are they concerned about the death penalty? Do they have information about the death penalty? Do they have knowledge? And there's very, very low levels of concern, a lack of concern, low levels of knowledge, and very low levels of information. And this is a very interesting question. We asked people whether they'd still favour the death penalty if it was shown that innocent people could be executed. And it's quite dramatic what happens to the original headline figures. In China, support dropped from 58% to 28% based on that question. In Malaysia, it dropped from 91% in favour of the death penalty for murder down to 33%, and 75% to 26% for drug trafficking offences. In Taiwan, the proportion who strongly opposed abolition shrank from 32% to 6% based on the concept of innocence and wrongful convictions. And in the US as well, support has fallen from 80% in '96 down to around 60% today, and we feel this is very much fueled and influenced by all of these wrongful conviction cases, as well as other issues like botched executions and a whole range of issues to do with discrimination, racial discrimination and arbitrariness. So this is really proof that supporters for the death penalty, it really rests on mistaken beliefs in the system that will be administered without arbitrariness, cruelty or error. And once you get behind that, you can show a totally different scenario. And the favourite question, I think, from these surveys is this one, is we ask the people to rank the death penalty as an effective policy. And in all the surveys that have been done, the people that say they support the death penalty actually rank the death penalty as the at the bottom of the list in terms of being an effective policy to reduce violent crime. So that's really the value of doing these surveys, and these results are quite instructive. And I'm pleased to say that the Malaysia survey that we did with Roger, this has now influenced policy. The Malaysian government have now said that they are considering abolishing the mandatory death penalty. We hope it will be abolished for all offences, but at least for drug trafficking offences in Malaysia. So this is these are the benefits of doing these types of surveys, is you defeat governments and policies and their reasons for retaining the death penalty. So in terms of what we've managed to do over 25 years, I go back to Pratt. This case, we're able to show that excessive delay on death row was inhuman and degrading, and this applied throughout the Caribbean. And then very fortunately, this same decision was followed in Uganda in a mass class action we brought for, it ended up for about 900 prisoners on death row in Uganda. And all 900 came off death row as a result of that case. That case also concerned the mandatory death penalty. The mandatory death penalty has pretty much been abolished through litigation throughout the Commonwealth Caribbean, but this has created a real movement to abolish the mandatory death penalty in many other countries that have followed suit. And we've seen the kind of harmonisation of comparative law in different legal systems. So these judgments coming out of London from the Privy Council have been very persuasive in litigation in India, in Bangladesh, in Malawi, in Uganda, and you can see this spread of law and this harmonisation of human rights standards around the death penalty. So that's been one of the most interesting areas from a jurisprudential perspective. The other area has been to challenge how clemency bodies, mercy committees operate. When I started, the old judgment from Lord Diplock was, you're lucky to have it. It's grace, not a right. You have no rights to mercy. If you save a prison commissioner in a fire, you might get mercy, but there are no legal rights attendant to the granting of clemency. And we've successfully argued again before the Privy Council, but also through a range of international human rights tribunals, that you have some procedural rights before a mercy committee. They've got to let you know what they're looking at, the information, some opportunity to make informed representations. And this makes a huge, huge difference. Ultimately, this administrative body called a Mercy Committee decides whether somebody lives or dies. So they must be governed by basic principles of fairness. Miscarriage of justice, we bring a lot of criminal appeals, so thankfully we're able to get some people off death row, and we bring a lot of complaints before international human rights bodies. So if people are interested in any of the reports, we didn't bring them with, they're quite heavy, but they're all available on our website. So if people are interested in downloading or getting electronic copies of the public opinion surveys, reports on miscarriages of justice, UK, Mai's report on public opinion in Japan, they're all available to read and download. So I've got a few minutes, so not many. So just very, very briefly, just 3 comments just to wrap this up. So what can I say about the last 25 years? Well, it's really been an adventure, I have to say. I mean, it's been fascinating. I mean, I wouldn't swap it for anything. I mean, it's pretty exhausting. I'm quite tired. Too much flying around the world, but it's been absolutely brilliant. But nothing would have been possible. We could not have done this on our own. So without the support of the law firm, without the support from so many members of the English bar, I could name hundreds, but I would name one, which is Edward Fitzgerald QC. He is a marvellous lawyer, one of the greatest lawyers alive today, and he has led most of this litigation. He has inspired a massive change in the law. And when I say massive, when I started there were 275 prisoners on death row in Jamaica. There are only 2 today. And that's through this 25 years of bringing case after case after case. We've managed to change the system, and Edward has been at the forefront of all of this. So I must mention Edward's name. Academics, people like Roger, people like Mai Sato, medical experts like Professor Nigel Eastman, who's one of the greatest forensic psychiatrists in the UK. He spent 20 years flying around the world going to examine my sick clients for nothing. So this wouldn't have been possible without all of this support. So, we're incredibly grateful to everybody who's supported us along the way. And I think we've all learned that have worked in this area is that to make a difference, it certainly takes perseverance, an open mind for sure, and being prepared to get up close to those on death row. From those early days I read to you about Jamaica in 1992, we've remained proximate to the problem and the human rights consequences of the death penalty. And that's what really drives us to keep doing this. I think the second lesson, and this comes pretty much from jurisprudence out of South Africa, is that you really do judge a society by how it treats the so-called worst, the poor, the marginalised, the outcast and the less fortunate. And that's something we've learned from our work for sure. And as Brian Stevenson, the great American lawyer, says, we're more than the worst things that we've done. And I think that's something that's very profound. So the final comments are really about the death penalty. So over the last 20 to 30 years, there's been a global movement towards universal abolition. And when I started, we were in the minority. We were certainly on the weaker flank. But things have changed so much now that it's really the retentionist states that are on the back foot. They are on the weaker flank and they are in the minority. And I hope in 10 or 15 years, I'll be out of a job. Thank you very much.
I think you would agree, ladies and gentlemen, that was an absolutely inspiring story. So, Saul, thank you very much. I guess we've got about 10 minutes or so for questions. Would that be about right? That's good. Excellent. So, I'm sure there's a lot that people would like to ask. Who wants to begin? Oh, please, no pauses.
Come on, old classmates.
Yeah, go on. Go.
Is it difficult for you to get sort of the consents or the agreements of some of the governments to be able to go in to do these surveys? I mean, it surprises me in a way, like with Malaysia, if they're so pro, how difficult it is to get.
Okay. Well, we have one main thing, which is we don't go anywhere unless we're invited to go.
Yeah.
So we don't just turn up in Malaysia saying we're going to change Malaysia. So we've got to be invited by somebody in Malaysia to say we need your help. So in Malaysia, we did the survey with the National Human Rights Commission. They asked us to come in to work with them and the Bar Council. So you have to have strong local partnerships, and then we can support them because it has to have local ownership. we want to get out. We've got other things to do. So we want to do a project, we want to give them the tools, and it's for them to advocate and to use those tools, and we can help them to do that. So that's really the answer to the question, is to have strong local partnerships wherever we work around the world.
I noticed on your list, I think number 2 was Iran.
Yeah.
Has there really been any movement there? I know you wouldn't be invited there, but you've got another 20 years to work on that one.
Well, we haven't been invited to Iran, but we did manage to try to train a number of Iranian judges in Malaysia. So the University of Nottingham have a strong human rights department, and they managed to get some funding to get 20 Iranian judges to Kuala Lumpur. And myself, Roger, and my co-executive director, Pervez, we spent a really hard week trying to talk to them about human rights issues. I think for us, the rule of law has really got to operate for us to be effective. So, I mean, where we've failed miserably in litigation has been in countries like Singapore. We've lost our cases in Singapore because the judiciary are not prepared to give an enlightened interpretation to the constitution in Singapore. But what's happened in Singapore is after 10 years of litigation, I think the government got so bored of us that they got rid of the mandatory death penalty through legislation. So sometimes you lose to win just by raising the issues constantly. We have been assisting a British national, an awful case in the Democratic Republic of Congo, who was sentenced to death by a military tribunal. Again, very, very difficult without a fully functioning independent judiciary. So as lawyers, we need that. So therefore, in those cases, we're much more reliant on Amnesty and other campaigning organisations to kick up a fuss. So we do need the system to operate properly.
Do you find it's a lot more difficult to contest the penalty where in countries where the Privy Council isn't available for appeals?
Yes and no. I mean, the Privy Council, you know, what the judges may think, the British judges may think individually or personally about capital punishment doesn't come into their judgments. You know, they're applying, in the Jamaican case, they apply the law of Jamaica, and they do that strictly, and they do that with huge integrity. So they may not like it. You know, it's difficult. But the countries that don't have the Privy Council tend to regard the Privy Council's jurisprudence as really persuasive. So there was a recent case that came out of Bangladesh, and they cited the Privy Council, they cited Lord Bingham's judgments all over the place. And so there is this comparative law element. And this man called Andrew Novak, an academic from the States, he's written all about it. So if you want to read about it, see the spread of jurisprudence around the world. Lawyers are quite interested in this phenomenon. But you can see how you can map out how the cases that started in the Privy Council have followed through common law Africa, and in some Asian countries, South Asian countries as well. But we also borrow the other way. So the Privy Council, we rely on Indian jurisprudence. We rely on jurisprudence from South Africa and Zimbabwe. So it cuts both ways. It's a very international exercise.
I hope you don't mind me playing devil's advocate. But I thought it was quite striking that 45% of people in the UK are still in favour of the death penalty despite being abolished for half a century. I just wondered what your thoughts are around that, if that is going to be a constant sort of moral belief in the UK, and if you expect that to change.
Well, I think there's two figures. I mean, there's the 45%, but that's not those who strongly believe in it. So I think that's a sort of superficial, abstract view. If you ask those 45%, do you strongly believe in it? Give them 5 options. No, I really don't like it, or I really do like it, with somewhere in the middle. You'll find that most people aren't really staunch supporters of capital punishment. But it's a very emotive area. I mean, I try not to do radio phone-ins, they're disastrous for me. But you generally get a lot of people calling in saying, I'm a crackpot, and, these people, deserve to die. I mean, this happens all the time, and what if it was a member of your family? And you can imagine the scenario. So people feel very strongly about it, and, I suppose it's very time-orientated as well. So if you had a poll the day after a horrific killing was revealed and splashed all over the newspapers, you could imagine how the people would react and the public would react. But the day after a horrible miscarriage of justice, you might get a different reaction as well. So I think, it's a very emotive subject. So people do feel very strongly about it. I mean, my grandparents did as well. I don't know why I'm doing this job, but so everyone has their own view about it, and that's fine. We don't moralise about it. I mean, I much prefer to take the pragmatic approach, which is it okay with you if innocent people get sentenced to death? Is it okay with you that people generally don't get fair trials? Is it okay with you that at least 60% of all the people we represent, and Amy and Catherine tell me otherwise, are mentally impaired? They have IQs in the lowest percentile of populations, and they're on death row. Is that okay? And then people might answer differently. So you don't have to moralise about it. My moral approach is no better than anybody else's. But what I do know is I know how the system operates, and I know the people that we represent. And I think that's quite telling.
So hypothetically, if those three criteria were met, if there wasn't a risk of miscarriage of justice, we weren't talking about sort of mentally disabled people, do you reckon there could be room for the death penalty? Or is there
Personally, no. I mean, killing is wrong. End of story. I don't really need to go beyond that. But I don't think that, as Gandhi said, an eye for an eye and the whole world goes blind. So you can take that and throw that around. But so no, state killing is wrong. It's no better, to take away a life because you don't like a killing seems to me to be illogical. And it's states have to behave rationally and not emotionally. So for a state just to behave on a policy of retribution isn't going to get us very far. It's not the kind of state I want to live in, for sure.
Are you troubled, Saul, just by the success you have will sometimes leave people in prison for many, many years after the success of your intervention in circumstances which really are fairly appalling for a very long time, perhaps almost the rest of their lives. What about that?
That's the next challenge. So, a number of people, very interestingly, we've got cases coming up, so watch this space, who were commuted because of delay on death row. Some of them were sentenced to natural life or, even worse, 75 years or 75 years with hard labour. Those cases are coming up to court. We're challenging the constitutionality of those particular sentences. We do believe that the punishment for heinous crimes is you're deprived of your liberty, but there must be flexibility in the prison system. There must be opportunity for prisoners to have reviews, and not everybody should be locked away forever. So this whole area of imprisonment is something that needs to be grappled with. It's a massive issue in the United States of America. There are 70,000 people serving life without parole. Pretty awful. So life without parole, we would never advocate to replace the death penalty. I'm going to give you an interesting story. We've done a number of challenges. When we reach the end of the day, we have to bring these challenges, not very pleasant, about methods of execution. So we brought a case in Belize. I won't name the barristers because I shouldn't. And we said that hanging was unconstitutional. We had amazing evidence from these absolutely crazy pathologists that exhumed the remains of people who had been executed. Who would do that? And they were able to show that their skeletal, their vertebrae were intact, so they choked to death. And the evidence is really with hanging is if you're very large, you're likely to be decapitated, and if you're not very large, you'll be strangled. So it's a pretty horrific method of execution. So we were arguing before the judges about this, and they were getting more and more irate, and they said to us, well, what do you suggest is the appropriate method of execution? And I thought, oh no, we knew this, we knew it was coming as well, and we just thought, well, whatever happens, we can't answer the question. And one of the barristers amazingly just said natural causes. And he was cited for contempt, I'm afraid. So he nearly went to prison, but bit of gallows humour.
And perhaps on a slightly lighter note, on a very serious topic, that's a good point to draw the questions and answers to a close. Ladies and gentlemen, I think it's been an absolutely fascinating evening, and it seems to be, Saul, that we talk about heroes when it comes to human rights, that it seems to be you are the absolute embodiment of a hero in the work that you have done over those 20 plus years. And so I think we can all say, those of us associated with the university, whether it's alumni or friends or current members of staff, we're absolutely proud of all that you've done. So ladies and gentlemen, Please share.